Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the President's conduct. The evidence we obtained about the President's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. Background legal and evidentiary principles. A. Legal framework of obstruction of justice. The May 17, 2017 Appointment Order and the Special Counsel Regulations provide this office with jurisdiction to investigate federal crimes committed in the course of and with intent to interfere with the Special Counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. 28 CFR 600.4a. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offences in mind. Our evidentiary analysis is similarly focused on the elements of such offences, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. See Justice Manual 9 to 27 et sequential, 2018. Here, we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the President. Those issues are discussed in a later section of this report, addressing constitutional defences that the President's Counsel have raised. See Volume 2, Section 3.b Infra. Three basic elements are common to most of the relevant obstruction statutes. 1. An obstructive act. 2. A nexus between the obstructive act and an official proceeding. And 3. A corrupt intent. See, for example, 18 U.S.C. 1503, 1505, 1512, C2. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering, see 18 U.S.C. 1512b, and describe the requirements for attempted offences and endeavours to obstruct justice, see 18 U.S.C. 1503, 1512c2. Obstructive act. Obstruction of justice law reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered, regardless of the means employed. United States v. Silverman, 745 F. 2nd, 1386, 1398, 11th Circuit, 1984, interpreting 18 U.S.C. 1503. An effort to influence a proceeding can qualify as an endeavour to obstruct justice even if the effort was subtle or circuitous, and however cleverly or with whatever cloaking of purpose it was made. United States v. Roe, 529 F. 2D 629, 632, 4th Circuit, 1975. See also United States v. Quattrone, 441 F. 3D 153, 173, 2nd Circuit, 2006. The verbs obstruct or impede are broad and can refer to anything that blocks, makes difficult, or hinders. Marinello v. United States, 138 S. Court, 1101, 1106, 2018, internal brackets and quotation marks omitted. An improper motive can render an actor's conduct criminal even when the conduct would otherwise be lawful and within the actor's authority. See United States v. Cueto, 151 F. 3D 620, 631, 7th Circuit, 1998, affirming obstruction, conviction of a criminal defense attorney for litigation-related conduct. United States v. Sintolo, 818 Fs 2D 980 992, First Circuit, 1987. Any act by any party, whether lawful or unlawful on its face, may abridge 1503 if performed with a corrupt motive. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus or connection to an official proceeding. In section 1503, the nexus must be to pending judicial or grand jury proceedings. United States v. Aguilar, 515 U.S. 593, 599, 1995. In section 1505, the nexus can include a connection to a pending federal agency proceeding or congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. The same at 599. See also Arthur Anderson, LLP v. United States, 544 U.S. 696 707 to 708, 2005. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. 18 U.S.C. 1515A1A. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offence. 18 U.S.C. 1512 F1. Although a proceeding need not already be in progress to trigger liability under Section 1512C, a nexus to a contemplated proceeding still must be shown. United States v. Young, 916 F 3D 368 386, Fourth Circuit, 2019. United States v. Petruk, 781 F 3D 438 445, Eighth Circuit, 2015. United States v. Phillips, 583 F 3D 1261 1264, 10th Circuit, 2009. United States v. Reich, 2479 F 3D 179 186, Second Circuit, 2007. The nexus requirement narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law prescribes. Aguilar 515 U.S. at 600, internal quotation marks omitted. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice, such that the statute excludes defendants who have an evil purpose but use means that would only unnaturally and improbably be successful. Aguilar 515 U.S. at 601 to 602, emphasis added, internal quotation marks omitted. The endeavour must have the natural and probable effect of interfering with the due administration of justice. The same at 599, citation and internal quotation marks omitted. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. Petruk 781 F3D at 445 to 446. A defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. United States v. Martinez, 862 F 3D 223 238, Second Circuit, 2017. Brackets, ellipses, and internal quotation marks omitted.